with proposed redactions because we believe that portions of it are not admissible, even in a preliminary hearing. And the way we did that is we provided a transcript and then a redacted version of the transcript of the entire video recorded interview. It may be that the court wants to look at the proposed redactions not while court is in session, but during some other period of time, because the transcript of the video, which we prepared and we provided to the state so the state could raise any concerns about the accuracy of the transcript, that's not an issue. The admissibility of portions of the video or the issue is about 20 pages, maybe 22 pages. The state is going to proffer a video 1102, a video recorded 1102. We have provided the state, I want to say about a day and a half ago, with proposed redactions because we believe that portions of it are not admissible, even in a preliminary hearing. And the way we did that is we provided a transcript and then a redacted version of the transcript of the entire video recorded interview. It may be that the court wants to look at the proposed redactions not while court is in session, but during some other period of time, because the transcript of the video, which we prepared and we provided to the state so the state could raise any concerns about the accuracy of the transcript, that's not an issue. The admissibility of portions of the video or the issue is about 20 pages, maybe 22 pages. So
let me repeat it, just because the audio may have cut out. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. Second, the court will address the camera operator and still photographer, and I will invite you to come forward. All right, the purpose of this is to ensure clarity regarding the expectations governing today's proceedings. Could you both state your name for the record?
Yes, Trent Nelson with the Salt Lake Tribune as the pool still photographer.
John Wilson from KSL Television, video photographer.
Good morning to you both. Have you reviewed the court's standing decorum order?
Yes, Your Honor.
Yes.
Do you understand the requirements set forth in that order as they apply to your activities today?
Yes.
Yes.
Do you require additional time to review the order or to adjust equipment to ensure compliance?
No.
No.
Okay. Do you anticipate any difficulty complying with the order or with the court's instructions?
No.
All right. Well, thank you. I appreciate your
Thank you.
cooperation today. As we begin this morning, the court wishes to acknowledge the importance of the safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the fourth floor. The court also expects every person in attendance will be treated with the dignity and respect to which they are entitled. Consistent with the court's standing decorum order, all spectators shall remain quiet, civil, and orderly during all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner. Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or other visible reactions during today's hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or opposing to any person connected with this case, or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, orderly, and faithful to the rights and dignity of every person involved. Turning now to counsel. Before we begin, I wish to acknowledge the professionalism, civility, and competence demonstrated by counsel for both the defense and prosecution during yesterday's proceedings. It is evident to the court that each of you approach this matter with seriousness, preparation, and a deep commitment to your respected responsibilities. The court appreciates the care which you have taken in advocating for your positions and the respectful manner in which you have done so. Thank you. Do either party require the benefit of the record before we proceed?
The state does, Your Honor. Mr. McBride will address the court.
All right, and just as a reminder, the microphones at council table are turned off to prevent the inadvertent capture of any communication. So if you would like to come forward, thank you. And turning to Mr. McBride.
Thank you, Your Honor. Before this hearing, the defense moved to find Article 1, Section 12 of the Utah Constitution, Rule 7B, and Rule 1102 unconstitutional as it relates to the admissibility of hearsay and reliable hearsay at this hearing. The issue was extensively briefed and argued. The court denied the defense motion to exclude the use of reliable hearsay at the preliminary hearing. That ruling is at docket number 631. In addition, defense counsel filed a standing objection on July 3rd. That's docket 678. The standing objection reasserted the arguments made in defendant's previous motion. Defendant continues to make these same objections throughout the testimony of each witness. I believe both the state and the court and everyone present knows that the defense objects to the use of hearsay or reliable hearsay at this hearing. On the point of preserving the objection, that has been done. Defense counsel has filed their motion, they filed their standing objection. Throughout the proceeding, they have continued to make objections. At this point, further objection is unnecessary to preserve the record and causes undue and unnecessary delay. This is needless delay, and we'd ask the court to acknowledge and the record to reflect the standing objection. And we also ask the court to give an instruction that continuing objections on this ground are unnecessary. Of course, if it relates to some other ground or is some item that's particular to a particular statement, that objection may be appropriate. But at this point, we feel that the repeated objections that have been made and already been ruled upon are unnecessary and cause undue delay.
Thank you, Mr. McBride. To defense.
Good morning, Your Honor. Michael Burt for Mr. Robinson. We have no objection to that procedure. As long as the court makes a ruling that the objections are preserved, we do think it would expedite matters if we didn't have to repeat the standing objection. There may be particular objections that are not covered by the standing objection we've made, and so we ask permission to be allowed to make those objections as needed.
Thank you, Mr. Burt. Thank you to both sides. I appreciate the presentation and your argument about this. The court takes no position in regards to whether the objection is made again and again or not. I leave that to the parties. I recognize the need to expedite this, and if both sides stipulate, I will adopt the request that the standing objection as it relates to 1102, Article 1, Section 12 of the Utah Constitution, and all relevant authorities that have been cited have been noted, and the standing objection by defense is in place. However, if defense feels the need to do that in order to protect the constitutional rights of Mr. Robinson, the court will not prevent that, nor stand in its way. This court is not is acting in the role of a magistrate and will allow the parties to move forward as necessary. But as noted, I will make that note that the standing objection has been noted for all of the yesterday's proceedings and will be in place throughout the rest of the preliminary hearing. Anything further or any need for the record given the court's statement?
Not from the state.
No, Your Honor.
All right, thank you. All right, the court acknowledges that the exclusionary rule is in effect. At this time, any witness who is subject to exclusion should be excused from the courtroom. And again, I will leave it to the parties to monitor the courtroom to ensure that if a witness has come in and they shouldn't be, that they are redirected. I invite Agent Hull to return to the stand. To resume direct examination, and Agent Hull, you are still under oath. Mr. Sturgill?
Thank you, Judge.
And before we begin, is there a way to dim these lights just a tad like we did yesterday? Perfect, thank you. All right, as of yesterday, there is also a water bottle to your left. And if you wouldn't mind just making sure that microphone is directly in front of you, we want to make sure that the record picks up your testimony today. Mr. Sturgill, your witness.
Thank you, Judge. Agent Hull, we're going to return to what has been marked State's Exhibit 12.1. There was reference to it yesterday. And I'd like to ask you again, have you reviewed that exhibit?
Yes.
And if you wouldn't mind, just briefly remind us what that exhibit consists of.
The exhibit is a compilation or a running of a summary of videos from UVU campus security footage that was obtained.
Okay.
Your Honor, excuse me, we can't hear the witness.
And that's what I hear. So let's go ahead and
Yeah.
stop. I'm not hearing it, so I'm going to have you repeat. Let's test it. Go ahead.
Check.
All right, I believe that.
Thank you.
Mr. Sturgill, if you wouldn't mind restarting.
I can do that, Judge.
Thank you.
Maybe bring the mic from the base a little bit closer to you. I don't know if that'll help. All right, let's go ahead and go back to what's been marked as State's Exhibit 12.1. I'd asked you a moment ago if you'd reviewed that exhibit.
Yes, I have.
Okay. And would you just remind us what that exhibit consists of?
It's a compilation of videos that were part of the overall footage that was obtained from the Utah Valley University as part of the investigation.
And does that compilation video, from your point of view, capture Mr. Robinson arriving to and visiting the UVU campus
It does, yes.
on September 10th through the 11th, 2025?
Correct.
Okay. And again, I asked you this question yesterday, but did you prepare that video compilation?
I did not.
Okay. Do you know who did?
The Utah County Attorney's Office.
Does that video, and I'm referring to 12.1 exhibit, State's Exhibit 12.1, does it include all of the footage collected by the SBI from UVU?
It does not, no.
Does that video, again, 12.1, include all of the footage you collected from UVU that captures who you believe is Mr. Robinson walking around campus?
Not all of the footage, no.
You reviewed this compilation with Mr. Olson, correct?
Correct.
Okay. And in its entirety.
Yes.
And he actually, and then you collected an 1102 statement from him.
I did, yes.
And I believe that has actually been admitted into evidence as State's Exhibit 12.3. Did Mr. Olson refer to that exhibit, 12.1, in his statement?
He did, yes.
Okay. 12.3. I'm going to put on your monitor State's Exhibit 12.3, and I'd ask that you scroll down towards the very bottom. And I would ask that you read from the statement specifically what Mr. Olson said about State's Exhibit 12.1. And I want to narrow your focus, so I'm going to draw your attention about 3/4 down the page. There's a sentence that begins on the left margin, "I have reviewed." Do you see that?
I do, yes.
Okay, would you please read that sentence?
I have reviewed State's Exhibit 12.1, and the recordings are true and accurate, including timestamps, dates, and camera labels. The only changes are some zooms and red highlights, which were not part of the original recording.
Okay.
Would
Have
like me
you,
to-
I'm sorry?
Sorry, I didn't know if you wanted me to continue. Or...
No, that's good enough. Have you had a chance, you reviewed the raw footage yourself, is that correct?
Correct.
And does that comport with your viewpoint of that exhibit?
It does, yes.
Have you had a chance to review what's been marked as State's Exhibit 12.4?
Yes.
Okay, and when did you review that exhibit?
This morning,
And who did you review that exhibit with?
with Kimberly Durfler.
Okay, was there any conversation about that exhibit?
No, I was just shown the video.
Okay. Nobody asked you questions or suggested anything to you?
They did not know.
Did you prepare that exhibit?
I did not.
Do you know who did?
The Utah County Attorney's Office.
All right. And I'm referring specifically to what's been marked State's Exhibit 12.4. What is depicted in that video?
That video is, again, a compilation of videos from the overall footage that was obtained from Utah Valley University for September 11th and September 12th.
And how does it compare to what's been marked as State's Exhibit 12.1?
It appears to be the same footage. However, on this particular version, there were no circles or blurs that had been made to the video.
How about zooming in and zooming out?
No, there was no zooming or zooming out.
Does it appear to be identical to the raw footage that you've seen that portrays this particular part of the UVU surveillance video?
It does, yes.